Well, good afternoon, everyone. My name is Martin Phillipson, and I'm Dean here at the College of Law at the University of Saskatchewan. It is my great pleasure to welcome you to the latest lecture in our McKercher Law lecture series, proudly sponsored by the McKercher Law Firm. But this one is a particularly special event in that this is the Gertler family lectureship in law honoring the Robert McKercher family. And we are delighted and grateful for the support of the McKercher Law Firm, but also to recognize the McKercher family, who were very supportive to a young Franklin Gertler in his time in Saskatoon and in Saskatchewan. So again, we're very grateful to the McKercher Law Firm for their continued support of our lecture series, but also I wanted to be clear that this is the Gertler family lectureship in law, which honors the Robert McKercher family, and of course, one of the founding founders of the firm. It is my great pleasure today to welcome Justice Nicholas Kasirer from the Supreme Court of Canada, and I would like to hand over now to Cameron Christensen of the Law Students Association to provide a formal welcome. And again, welcome everybody, and thank you for your attendance today.
Good afternoon, everybody. I hope everyone can hear me okay. As the Dean mentioned, it's my pleasure today to be able to welcome the Honourable Nicholas Kasirer. So Justice Nicholas Kasirer graduated from McGill University in 1985 with a Bachelor of Civil Law and a Bachelor of Laws. This was prior to achieving his Bachelor of Arts from the University of Toronto. In 1986, he completed a postgraduate studies program in international law at the University of Paris. After clerking for the Honourable Jean Beats of the Supreme Court of Canada, he became a member of the Bureau de Quebec in 1987. From 1989 to 2009, Justice Kasirer was professor at McGill University's Faculty of Law, where he taught in several fields, including the law of obligations, property law, and family law. This was in both the civil law and common law contexts. Justice Kasirer held the James McGill Chair in Law from 2002 to 2009 and directed the Paul-André Capreux Center for Private and Comparative Law from 1996 to 2003. He served as Dean of the Faculty of Law at McGill University from 2003 to 2009, and in 2009, he was appointed Justice of the Court of Appeal of Quebec. Following this, in 2019, he was appointed Puisine Justice at the Supreme Court of Canada. In 2006, he was elected titular member of the International Academy of Collaborative Law in Paris, and in 2008, elected Fellow of the Royal Society of Canada. In 2012, the University de Sherbrooke awarded him an honorary doctorate in law. The floor is yours, Justice. I look forward to hearing your presentation.
Well, thank you so much, Cameron. Thanks, Dean Phillipson, and thanks especially to the College of Law for this great and happy honor to speak to you today. I wish so much I were at the College of Law in person, and I'm grateful to all of you one more time for suffering the indignity of a lecture on Zoom. I bring greetings to the college from the Chief Justice of Canada and your many friends and admirers at the Supreme Court. The misery of the pandemic is such that you're always patient and optimistic. Dean and I have been exchanging emails for a couple of years now about this lecture in medical law, and he knows how disappointed I am that I can't be with you in person. When he first wrote me, I jumped at the invitation for three reasons. First, I know that the Gertler family set this lecture up to honor Bob and Peggy McKercher and to celebrate the McKercher connection to the University of Saskatchewan. I had the pleasure of working alongside Bob for many years as a trustee on the board of the Canadian Foundation for Legal Research, a trust initially set up under the auspices of the Canadian Bar to provide financial support to lawyers and scholars across the country. Bob McKercher was a leader in that setting and in many others, and I know that his partner Peggy was a great servant to the University of Saskatchewan. It's a privilege for me to participate in this lecture that bears the McKercher family name. The second reason I'm pleased to be here is that on every visit I've made to Saskatchewan, whether as a law professor or as a judge, I've observed this province to be the home to one of the most dynamic, engaging, and welcoming legal communities in the country. I have friends at the bar dating back to the time of my own clerkship at the Supreme Court, as well as lawyers I've come to know in the public service and the practice of law in Saskatchewan. And of course, I know that some of Canada's best jurists sit as members of the Saskatchewan judiciary. Monsieur le doyen, vous me permettrez de signaler aussi tout mon attachement à la communauté juridique de langue française en Saskatchewan, ayant à l'esprit de bons souvenirs de mes échanges avec les juristes fransaskois et fransaskoises dans le but de faire de la promotion de l'administration de la justice dans les deux langues officielles au Canada et en Saskatchewan. There's a third reason that I'm honored to be here today. As a person interested in scholarship in the law, I hold the College of Law in especially high regard. I'm something of a constant reader of the work of a number of professors and teachers at the college, both in private and public law. And I'm not alone here at the court in that regard. I would add that for someone like myself, for whom comparative law has been a concern since the start of my career, I've been particularly admiring of the work done at the college in Aboriginal and Indigenous law. I salute how the college has become a leader in championing the idea that in Canada, law comes from multiple legal traditions. And the college has rightly embraced the notion that for all of us, that Indigenous legal traditions help complete legal education in the common law or the civil law. I share your view that Canada is a richer place juridically, and that legal education is enlivened by the recognition of legal pluralism at the core of Canadian legal culture. My topic today, medical liability from a civil law point of view, une leçon fransaskoise, seeks to highlight the connection I feel as a Quebec jurist interested in medical law and as a judge working in Ottawa for this idea of the richness inherent in Canada's legal pluralism that is flourishing here at the College of Law. Well, what possible bridge, you might well ask, is there between medical liability in Quebec and Saskatchewan? The more suspicious amongst you might worry that this is part of some vast plot to colonize the common law with the civil code, to foist upon you a far-off law of dubious relevance and potentially confounding influence, the development of principles of negligence as applied to doctors and other health professionals. Well, it's certainly true that you're doing quite well without the musings of ancient Romanists like Gaius and Justinian. And my purpose today is not that of a colonizer. But there is, in fact, a real connection, I think, and in fact, quite a palpable one between Saskatchewan and the law of medical liability in Quebec. And that's Paul-André Crépeau, Professor Crépeau, whose photo appears here. It was a preeminent scholar, law teacher, and law reformer. In fact, the preeminent Quebec scholar in the 20th century, who, as it happens, was born in 1926 in Gravelbourg, Saskatchewan. And he never lost his interest or attachment to the province and to your law. It's hard to overstate the influence that this Saskatchewan-born jurist had on the development of Quebec private law. At a period of Quebec's history, from the years preceding the Quiet Revolution down to his death about 10 years ago, where socially, economically, and juridically, Quebec emerged as a modern political identity. His principal contribution was to public life was that as president of the Civil Code Revision Office from 1965 down to the early 1990s, which led to the reform of the Civil Code of Quebec, part of the great social construction of this modern Quebec, and hailed the world over as one of Canada's fundamental contributions to private law. Professor Crépeau taught law at Quebec law faculties as part of the first generation of full-time law teachers. He taught for over 50 years, principally at McGill and also at the University of Montreal, focusing his energies mainly on the law of obligations, that is to say, contract and delict or tort, and infusing Quebec law teaching with values of scholarship in the French university tradition that were closer, I think, to the law books and to scholarly work than it was to work before the courts. He was a major writer, contributing many works of lasting value to private law, including among them one of his best known works, the Private Law Dictionary, the Dictionnaire de droit privé, that is read all over the civil law world. I'd ask you, so here's an image of the report of the Quebec Civil Code that he, I could just stop for a second, that he orchestrated, which reformed the whole of Quebec private law and led to the new expression of Quebec's common law in the form of a civil code, and came into force in 1994. And then of his many works of scholarship, this is one of his best known, the Private Law Dictionary in French and English of fundamental concepts of Quebec private law. He is, it's certainly true to say, both in Quebec and internationally known as the spiritual father of the renewal of the civil law, a sort of portalise figure for the Civil Law Canada. His worldview was marked, I think, from growing up in Saskatchewan, a part of a devout French-speaking family, a sense of his minority place in the community, and that his own perspective on difference was such as to animate much of his intellectual life. As a young man, he studied with the Oblates at the University of Ottawa before taking law at the Université de Montréal. There was nowhere to study the common law in French in those days in Canada. And he had what he would himself describe as a life-changing experience as a Rhodes Scholar in Oxford when he took a BCL. He read for the BCL, studying the fundamentals of contract and tort before moving to Paris, where he completed a doctorate on comparative medical liability, our topic today, dealing with French law, English law, and Quebec law, which was published in 1955 under the tutelage of France's great comparative lawyer, René David. So here's a copy of the book that was published, his doctoral thesis. And soon after that, he was hired to teach law at the Université de Montréal, about the same time as his old friend and fellow Quebecer at Oxford, Jean Betts, who would go on to the Supreme Court. And the story is that when Professor Crépeau and Professor Betts arrived as young men at the University of Montreal, it was Crépeau who was assigned to teach constitutional law, of which he knew nothing, Betts, who was asked to teach obligations, of which he knew little, and they quietly swapped teaching loads in the professor's lounge before the start of their first year of teaching, and the rest is history. Over the coming 55 years, Paul Crépeau remained devoted to a life as a scholar of the law. He resisted many other temptations to do other things. He was appointed as one of his crowning achievements as the president of the International Academy of Comparative Law. He would receive dozens of honorary degrees, including one from your university in 2008, the Légion d'honneur. He was a companion of the Order of Canada. And he died in 2011, still a professor working hard on his great treatise on the civil law, which he left in manuscript form. Well, the law relating to the liabilities of doctors and hospitals that Professor Crépeau encountered in the 1950s as a graduate student in England, France, and Quebec was, by his own account, unprincipled and lacking in all semblance of order. For him, English law in particular, where facts drove the law through the cases, where writs trumped rights, was pragmatic, but he felt highly undisciplined, something like chaos with a weak index. French law, a law which he revered, which in manner and form was, in his view, the highest expression of modern legal thought, was oddly and unnecessarily chaotic too in matters of medical law. And the fabled abstract rationality of the French Code Civil seemed unable to tame circumstance. And he thought the law of extracontractual obligations was particularly a tort, particularly unsuited to explaining the doctor-patient relationship. In the short time I have with you today, I want to focus on one of Professor Crépeau's most important ideas for explaining the law of obligations, and particularly the liability of healthcare professionals, the notion of the intensity of an obligation, a subject to which he devoted great thought in one of his best books, L'intensité de l'obligation juridique, which you see here on the screen. Not unlike the common law, even though English law, of course, doesn't use this kind of terminology, the civil law imagines the relationship between doctor and patient as one between debtor and creditor of an obligation, rather than simply unrelated defendant and plaintiff in what a judge may or may not understand as a duty of care. In the civil law, the physician owes the patient an obligation, but it begs the question, what's the content of that obligation? In the same sort of way that one inquires what the standard of the duty of care imposed upon a doctor in the like setting. The problem, of course, is that medical acts designed to diagnose a health problem or treat a malady face a great range of variables. How will the patient react to the treatment? How does the patient have an underlying condition? And in both the common law and the civil law, at the end of the day, one recognizes that in most cases, a doctor does not guarantee results to their patients. There are just too many risks involved. We content ourselves in both traditions with the idea that reasonableness is the right measure of performance in such matters. So to take one of the leading cases in the field in common law Canada, Terre-Neuve against Korn, the 1995 Supreme Court case from BC that many of you have no doubt read, which deals with a patient who, while undergoing artificial insemination, was infected with HIV. The negligence standard is applied, and the courts say something like, well, physicians have a duty to conduct their practice in accordance with a prudent and the work of a prudent and the standard of a prudent and diligent doctor in the same circumstances. And where that is a specialist, the measure is that of the ordinary specialist who possesses, of course, the reasonable level of knowledge and skill in the field. Well, the civil law applies as a general matter, a nearly identical rule. Again, not surprising. We wouldn't expect doctors to answer to a different standard in Saskatoon or in Montreal. But it's spoken to in the language of intensity. The intensity of the obligation owed by the physician to their patient is said to be one of means. That is to say, they must act diligently according to the standards of the reasonable physician or specialist in the circumstances. And they're not held to guarantee results to their patients. And similar problems arise where the medical act is one of routine, where the requirement of performance in keeping with that norm comes close to ensuring happy outcomes for patients. When that doesn't happen, liability for the doctor. So in Quebec's leading case, Supreme Court judgment in Lapointe against Hôpital Le Gardeur, a 1992 case, a physician who was a specialist was held to have to exercise the degree of skill of the average specialist in the field. And the physician's conduct was judged in light of the knowledge and skill they ought reasonably to have had at the time of the alleged act of negligence. Now, interestingly, in Lapointe, like the Terre-Neuve case, courts warned against applying the standard of perfection to physicians, given the average specialist's limited ability to foresee complications. And not surprisingly, perhaps, when 3 years after Lapointe was decided and the court faced facts in the BC case in Terre-Neuve that were broadly similar, Justice Sapinka cited the Quebec case, which relied on Professor Crépeau's work, where the same norm had been applied, and cited that case, Lapointe, with glowing approval. as I say, the content of the rules in the common law and the civil law appear to be broadly similar, but their shape are different. In the civil law, shape is an all-important matter. The relationship between the doctor and their patient, as I say, is imagined as an obligation, a legal bond, or as Roman lawyers would say, a vinculum juris, whereby the object of the obligation, civilians use the word prestation, that which must be done or not done, is the substance of the debt owed by the physician to the patient, the debtor to the creditor. Whether the obligation is one founded in contract or delict, that prestation is owed and can be analyzed. Thus, the celebrated unity of the obligation in the same way. And law students in France, Italy, Spain, Germany, and indeed in most parts of Quebec don't take separate courses in contract and tort. They understand the obligations as being a single phenomenon. So here we're going to look at how a valid obligation in its content will vary, and vary according to what Professor Krasier called its intensity. So what then is, conceptually speaking, is the intensity of an obligation? For the beginning of an answer, I turn not to the civil code, but to this scholarly work that Professor Krasier worked on, the Private Law Dictionary of Obligations, of which, among his many publications in the civil law, Professor Krasier took particular pride. The civil law dictionary defines the intensity of the obligation across contract and tort, as you see on the screen, as the extent to which the debtor must bring about a projected outcome, the debtor being here the doctor, the projected outcome, the desired healthcare outcome, as is prescribed by law or by contract. There was a long debate in Quebec law whether the doctor-patient relationship was one of contract or one imposed by law. So for whatever the obligation might be, say a garage mechanic, the projected outcome being the fixing of, I don't know, a leaky radiator, or for a FedEx, it's the delivery of a package on time. And for the physician, it's the curing or treating of whatever ails you. In each case, the content of the obligation will vary according to the obligation's intensity. And the civil law provides a pre-existing grid, a sort of trinity of the intensities of the of obligations, classified into three categories. The obligation first of means, which is where the debtor has the obligation to act with prudence and diligence. The creditor of the obligation, for us, in our case, it's the patient, must prove the fault of the doctor by showing that the latter did not act with the requisite diligence in service of the desired result. And beyond the professional setting, the obligation of means is invoked to explain the tenor of different obligations, say, the tenant who must care for rented premises as would a reasonable and prudent person in the circumstances, or the agent or mandatory, as it's known in Quebec law, for the execution of their duties. Next, the obligation of result, the second form of intensity. That's an obligation that's stronger in content. The plaintiff need only show that the outcome did not arise, and the burden is thrust upon the defendant debtor to show that liability should be avoided, which he or she can do by showing force majeure, or superior force. The obligation of a transporter, for say, generally understood as one of result. You must transport the goods that you undertake to deliver. And you can only extract yourself from failing to do so by showing superior force. the travel agent, the garage mechanic, all of these debtors can only be relieved by showing that the outcome was not their fault, but it was some intervening actor. And the third form of intensity is the obligation of warranty in the civil law. All of these categories, of course, absent from the common law, at least absent in a formal sense. Here, the obligation to bring about the specific and determined outcome is imposed, and even proving superior force doesn't extract you. Examples sometimes given include the obligation to pay a sum of money in some certain contracts, or the obligation of a vendor to warrant against defects of quality in the product sold. As a general rule, the obligation of a physician, as I say, is understood as one of means, that in that the debtor physician is not held to guarantee the result of the treatment they prescribe for their patients, but merely to take reasonable steps to ensure that that projected outcome, good health for the patient, will come about. Sounds very much like Ternusen. The intensity of the obligation imposed on the physician is to take those reasonable steps, as would the ordinary doctor in the circumstances, to heal or to treat the patient. The measure is understood to be a flexible one and varies according to the circumstances. When a doctor performs a technical standard task, they're held to an intensity of means rather than saying that the result must be assured. Courts tend to say that all doctors placed in those circumstances would have taken the easy steps that the defendant doctor may have failed to do, and thus the familiar standard is imposed. So all of this sounds, if one gets beyond the name tags, familiar to the common law when it proceeds to deal with like disputes. So fairly or unfairly, the intensity of means is generally invoked for all professionals based on the idea that the nature of the services offered by, say, a veterinarian, investment advisor, or chiropractor does not lend itself to guaranteeing results. So accordingly, a lawyer, for example, is held to a similar standard. And naturally enough, a tax specialist is held to the standard of the reasonable tax lawyer in the circumstances. On the other hand, where the character of the prestation, that is to say, the content of the obligation, dictates otherwise, it's fair to impose a stricter intensity on, say, the garage mechanic undertaking a standard mechanical task, who should come much closer to guaranteeing the result and only escape liability if they show a supervening event that precluded them from performing the obligation according to its intensity. So there it is, that classical pre-existing taxonomy of obligations according to intensity. And beyond describing the positive law, I'd like to take a step back and observe what the taste of classification means for civil law culture. As a general matter of method, the civil law has embraced, since Roman law down to today, a general classificatory approach to the law, and the exercise of classification of ideas is seen as one of the defining features of civil law reasoning. Classification of legal ideas is taken, as I say, prior to a problem arising as a matter of lived experience. Unlike the common law, where facts adduced in court drive the shape of the law, the civil law is characterized by a way of knowing, a legal epistemology, in which the architecture of the law is set in place first, and facts are, in some measure, slotted in, after the event. The principal locus for the development of legal ideas is not the courtroom, but the classroom. By that, I mean to say that since Roman law, the culture of the civil law emphasizes scholarship as the principal site of the exposition of the law, and not reasons for judgment following a dispute. This explains, one might think, why in the social hierarchy of law in France or Italy, for example, The professor is the exalted figure, whereas at least on the traditional measure for English law, the oracle of the law is the judge. A return to the centrality of the classification in civil law culture that Professor Crapo held so dear. The law's ambition, and indeed the scholar's task, is to present a picture of the law before any dispute may arrive that is coherent, systematic, and comprehensive. This presupposes a structure of ideas for private law that is both categorical and seamless. Much of civil law scholarship is devoted to developing or elaborating this abstract categorical grid. This is done by classifying legal ideas according to the strictures of abstract rationality and placing them into this preordained system. Common lawyers, of course, tend not to be as concerned with this elaboration of a pre-existing grid. They're content to elaborate the law on the basis of what used to be called judicial words and phrases, a systematization that defies the fact-driven, problem-solving, experiential character of the law is key. The common lawyers who chart out maps in advance of disputes. For example, one thinks of the great Oxford teacher Peter Birks in respect of his work on the law of unjust enrichment, are sometimes seen as outsiders in English law. And in the case of the very learned Professor Birks, as sort of crypto-civilians. The exercise of classification is, however, at the core of the intellectual culture of the civil law. One might argue that Quebec stands a bit apart in this respect. It's not the plainest exemplar of civilian method. Of course, Quebec law is a mixed legal culture evolving in North America, closely connected to the powerhouse influence of the common law, and where, and this is important, Quebec judges might be seen as closer cousins to English judges than to continental judges, given the powers and roles that superior courts on the English model in the province of Quebec enjoy, and the unusual status associated with judicial lawmaking. That said, classification as an organizing technique in the civil law, and in particular in the law of obligations for Quebec, is an undoubted feature of the province's distinctive legal epistemology. The law of obligations was famously organized in the 18th century by French jurist Robert-Joseph Poitiers in his famous Traité des Obligations, published 50 years before the French Civil Code that he inspired. Poitiers drew on Roman law, the custom of Orleans, natural legal principles, and legal philosophy to organize the whole of the law of obligations into categories that provided the scaffolding for Quebec law when it enacted the Civil Code of Lower Canada in 1866. And from there, the ambition of the law of obligations in particular, and of scholars, Quebec scholars such as Jean-Louis Baudouin, Benoît Moore, and Didier Luel, Jean Pinault, who've written modern scholarly treatises in the field, is to elaborate this grid, this general, to present the law in a rational and systematic manner that rests upon these classifications and subclassifications that are abstract for the basic institutions that others must learn. And the application of those categories is really left to afterthought. Indeed, traditionally in the civil law, the most refined classifications of ideas have been those announced through the scholarly commentary in the law of obligations by authors such as Paul Crapo. Obligation structure, of course, all of the events of civil life between private law actors that produce financial claims. Obligations encompass all of the law of contract and tort, all of quasi-contract, that is to say, restitutionary claims, and quasi-delict, what the common lawyer refers to as negligence. Obligations are classified according to these sources, but there are a variety of other axes, classification by nature, object, effect, and of course intensity, to name just these. This is an intellectual exercise, classification. Sometimes the classifications are conceptually satisfying, but frankly, practically of little value to a judge or a practitioner. What's important for the civilian imagination is that the classification is learned and takes place, that it be undertaken as an abstract endeavor, and that it not be driven solely by the facts. The classification on the basis of intensity of the obligation tells a particularly compelling story about civil law methodology. Interestingly, classification by intensity is absent from both the Quebec and French civil codes. It's truly scholar-made law. And it was, in fact, it emerged in the early part of the 20th century in France initially to organize the parts of the law of obligations that later Professor Crépeau found to be an organization he found to be lacking in medical law. The term intensity seems to have been coined first by French professor René de Mogg and brought to the fore by celebrated scholar Henri Mazot in an essay he wrote in the 1930s. But it was absent in Quebec until Paul Crépeau, at the time a very relatively young scholar, wrote a paper in the Canadian Bar Review calling for an overhaul in respect of the content of obligations, drawing in large part on the work he did on medical liability in France, in the United Kingdom, and in Quebec. So since that time, since the late 1960s, the law of intensity has been a mechanism for assigning liability, whether in contract or tort, before the courts in Quebec, the courts sort of following the lead of the scholars. The obligation of means is, without a doubt, a central premise of medical liability in Quebec. Professor Crépeau believed deeply in the architecture, that the architecture of the civil law of obligations depends on these a priori categories of what one might call structures of civilian legal knowledge. For generations, they've served to organize the law. His commitment to this was not as a problem solver for the courts or for the practice, or even as a law reformer, but first and foremost as a teacher and a scholar. He believed the exercise of classification was above all an intellectual endeavor that served to shape the civilian imagination. It was an instrument of teaching and scholarly speculation in the tradition of the civil law. In addressing these short remarks to you on the influence of Paul-André Crépeau on private law in Canada and on medical law in particular, I hope to make this small link between Quebec law and the law of negligence in the common law tradition that dominates the teaching of medical liability across the country. I hope to, by introducing to you the person of Professor Crépeau and some of the values that anchored his pluralistic approach to law, his championing of linguistic diversity, his intellectual curiosity, that you recognize some of these same values at present in the life of the law in Saskatchewan. At the core of his work was a commitment to the idea that law was richer for its diversity, linguistic, coming from multiple traditions, and that the comparative exercise makes us better jurists. In that spirit, I salute the work done here at the College of Law, long-standing and profoundly important, on Indigenous legal traditions as holding up an alternative way of imagining the law as it should be studied at a Canadian university. And recall for all of us that with the civil law, there is already an idea in Canada, alongside the common law and Indigenous legal traditions, that the law in Canada is not univocal. With that, I thank you for this kind invitation, salute the McKercher family, and look forward to seeing you all in person at an early occasion.
Thank you. We've opened up the floor now to questions, to question and answers. So far, though, there is nothing in the chat. And I do not see anybody with a raised hand at the moment. Oh, we do have one question right now, and that's from Dean Phillipson.
I'll defer to Professor Rochette first.
Okay.
Justice Kasirer, Nicolas, nice to see you. I don't have a question. I just wanted to chime in with my experience as a student of Paul-André Crépeau at McGill in 1990. And having studied all of this intensité de l'obligation and la pointe contre le gardeur, and it all came rushing back to me. And it was such a, it was truly an amazing experience to be his student, because his passion for the civil law and the comparative law was really inspiring. So I just wanted to chime in as a student of Paul-André Crépeau. And I remembered all of these things, and I read L'intensité de l'obligation juridique, and so it was really nice to hear about him again. So thank you.
Well, I was thrilled to learn that, Professor Rochette, that you've been that you're joining the College of Law to teach. What you're a great expert on legal education, and maybe teaching about polygirality in Canadian law is something that you'll introduce to your students. I hope so. Yeah,
and I think Paul-André Crépeau would have been it would have been nice to have him still around today when dealing with how to incorporate Indigenous law and stuff in Canadian law. So it's too bad he's left us.
I agree.
Okay, thank you, Rochette. Dean Phillipson.
Yes, Justice Kasirer, thank you very much for the remarks. Comparative law classes in common law schools aren't always of the highest enrollments, shall we say. If there was anything you could say to our students about the importance of learning and studying law from a comparative perspective, you've given us a context in medical liability. What would you say to a student who is considering studying comparatively, and why is that so important that they take those different perspectives, and how will it enrich their education or understanding of the law?
Well, I allow myself to go back to the example of Indigenous law. I remember a story that was told to me when I began law teaching about a professor of teaching real property law in one of the common law schools in Western Canada in the, this would have been in the 1980s. And the professor stood up and started the class in common law property with that great phrase that for generations was the first line that a professor would pronounce before a first-year class: "The king owns all land," which was thought to be the conceptual opener upon which the doctrine of tenure and estates would be developed. And the story was told that an Indigenous student sitting in the front row stood up and walked out because, according to her conception of the law, that made no sense. So the story is an important one in the sense that it shows that there's different ways of imagining what law is, and that no one of them monopolizes the truth as to what legal ideas should be. And as I say, one of the great virtues of what you're doing at the College of Law in bringing Indigenous legal traditions to the fore is confronting people to comparative legal ideas. It's nice to know that Canada is a world leader in this respect because of bijuralism as part of our legal DNA, if you will. And so in an odd sort of way, there's nothing more pressing than comparative law. It's true, of course, though, that low enrollment is generated by the dominant paradigm, which is that of the jurisdiction. And when you're studying law through the lens of a jurisdiction, law is either applicable and thus relevant, or not applicable and thus irrelevant. And so the comparative endeavor seems lost. But even from that point of view, thinking of legal ideas as legal ideas with the potential for persuading people rather than binding them with the strength of the view expressed is something that we do all the time. So we're constantly comparing legal ideas. We're constantly looking at ideas from other places and other cultures. And I think it should be more formally recognized as part of legal education.
Thank you. Does that answer your question, Dean?
Yes, and I hope it answers some of the students' questions as well, which is very helpful.
Okay. Is there anyone else that has a question this time? There is one more question, and it's the question is coming from a student, and the question is, in your experience, how often do you feel that the comparative process serves to inform the dominant legal understanding in practice?
Well, not enough, I would say, because one of the reasons that the dominant practice is that it purports to have a monopoly on the truth of the ideas that it treats. But if you look carefully at I'm just thinking of two papers that I've read recently by professors at the College of Law. And if you look critically at what the sources that they cite, it's not so much that they cite the civil law or cite law from some far-flung jurisdiction, but just there's a kind of a literacy with ideas that come from other disciplines, analogies made to different areas of the law. People are constantly comparing, even within the so-called dominant legal culture. So I'm optimistic about comparative work. And as legal studies become more scholarly, more driven by the values that we see elsewhere in the university, and that's certainly the story of the last 25 years at this university and elsewhere. Comparative work, locating law in the world of ideas, is something that's going to be increasingly familiar to everyone.
Okay, thank you. I think a lot of people are focusing on the comparative, aspect between, of course, like the civil and the common law, and then, of course, the multi-juridical aspect that happens with Indigenous legal orders, which are just now coming more to the forefront. But I know that even within the law school, the acceptance that the Indigenous legal orders and the benefits that could happen with the use or the space of the dominant legal system is still something that is a very live and controversial issue, at least even within University of Saskatchewan. If we look at what's going on with the TRC implementation. So my question with that, though, is when you speak about the multi-juridical legal system that we have here, we have the recognition formally of the civil and the common law. Do you have any ideas or suggestions on how to bring about more space for other juridical systems, right? Because the trans-systemic is important within Canada.
Mhm.
And then with this, I think that'll be the last question. And then we'll hand it over to the Dean to wrap up. But thank you.
Ms. Lavallee, I don't have a good answer for you. The legal positivism champions formal legal institutions and legal orders, and that leaves a place for the common law and the civil law, and tends to leave less place for other legal traditions, whether they be from whatever source they may come by. But if you look at the way in which Canadians conduct their lives, you can watch them following the strictures of rules, of norms that come from other places, governing their private lives, their religious practices, their community practices. So legal pluralists, some great Canadian legal pluralists, I'm thinking of scholars such as Rod MacDonald, have argued strongly that we shouldn't be duped into thinking that Canada's merely a bijural legal order, that polyjurality is the order of the day. But your question is a tough one.
Yeah, I don't think we have any of those answers yet, but I just looking for different people's ideas and different people's viewpoints, because that's how we get where we're going to get, right? With a diversity of views and implementation, according to, I think whatever's the better decision, especially even locally. And that's, I think that's all we have for today. And Dean Phillipson, did you want to thank our, I'm going to thank you as well, but I believe that the Dean is now going to formally thank you as well as all of our audience that tuned in today. So again, thank you. And I will leave you all be. Thank you.
Thanks, Professor Lavallee. I want to thank Justice Nicholas Kasirer for spending his time with us today and giving us a very thoughtful and intellectual presentation about bijuralism, polyjuralism, but also the contributions of a great Saskatchewanian. We're very proud at this school of the contributions that many of our alumni have made in the 112 years of graduating classes of this school. The ethos of the school in the first years, always hate me say this, is lawyer as public servant. And I list many of our graduates who've had great careers in the public service, both in small p and s and in large p and s. And we would certainly think of Professor Crépeau as being a great servant to Canada and the law in general. And we're delighted that Justice Kasirer highlighted his contributions. I'd also like to remind everybody that the Gertler Family Lecture in honor of the McKerchers is a fascinating story in and of itself, in that Maynard Gertler was an alumnus of the University of Saskatchewan and an internationally renowned cardiologist who actually was the cardiologist to an American president. And it honors the McKercher family, whose various members assisted Dr. Gertler in the launch of his career in medicine in Saskatchewan. So another, again, wonderful story about the rich history of this province and the contributions that people from this province have made. Again, I would like to thank Justice Kasirer for his presentation. I've said to him in our many phone calls, there is a standing invitation for him to visit the school at any time. He'd be most welcome. I want to thank you for taking the time out of your busy schedule to deliver a scholarly and intellectual presentation. And I'd also like to thank our participants today for their questions and for their attendance, and also again to the McKercher firm and to the McKercher family for their continued support of the College of Law and for us bringing really high quality speaking events to the public and to our legal community. I will finish by saying there is one lecture left in the McKercher series this year, and that is another McGill alumnus, David Lemeni, who is the Federal Minister of Justice, will be delivering the Saskatchewan Law Review lecture on the 15th of March, I believe. And I would encourage you all to attend that if possible. Again, I want to thank you all for attendance. Thanks again to you, Justice Kasirer. I hope to meet you in person sometime very, very soon. And I wish you all a good day. Thanks to everybody and have a good day.